Hi, I'm attorney Gregory Dell here with attorney Stephen Jessup. And Steve, I want to talk to you today about a case that you were able to successfully resolve recently on behalf of one of your clients. I believe it was a claim against the Hartford Insurance Company, of which I know you've handled a couple hundred appeals and lawsuits specifically just against Hartford. So could you share what this case was about, how you were successful, and what the outcome was for our client?
Yeah, and this was a case originally, the client came to us in the beginning to do the application. We assisted him, we got the application completed, the claim was approved. Shortly thereafter, at that time, he decided he wanted to handle the case on his own.
Which is that's unusual.
Unusual. He decided with respect to, the way he had hired us that he wanted to handle it on his own, was approved for Social Security, so he thought he was realistically going to be in the clear. About not even 10 months after he did that on his own, Hartford came back around and denied his claim. Basically taking all the information that had already been there and just saying, hey, we don't see anything here to prevent you from doing your job. And this is a client who had rheumatoid arthritis. And one of the interesting things about this specific client is the rheumatoid arthritis, and when you think of that, you think of pain, you think of swelling and inflammation, you think of pain, a pain condition. He did have that, but to him that wasn't the most debilitating portion of his claim. He was having more effects with cognition, his ability to recall and remember. And this was a guy who was at an executive level position for his former employer. So the issue became with Hartford when they were denying him, well, your doctor reports that your pain is being tolerated well. You do say that you have problems with your memory and thinking, but there's nothing in the evidence here that would suggest that you have any legitimate problem that prevents you from doing your job. They went back to that same kind of story that you can do sedentary work. We don't see why you can't, and they denied his claim. So he contacted our office again to assist him with regards to the appeal. It was also in an interesting time. His policy had a 24-month change in definition from own occupation, any occupation, and the denial of benefits occurred only 3 months before that switch. So Hartford was setting it up that they could approve those 3 months of benefits and then deny going forward under the any occupation standard if they wanted. So in preparing the appeal, we try to address all of those things.
Hold on, I want to slow you down 1 second because I just did another video just a few minutes ago with Cesar Gavidia, one of the other lawyers, and it was Aetna, and now Aetna and Hartford are one company. And this is a strategy that we're seeing all the time, we've been seeing, is let's go ahead and deny the claimant during the own occupation stage, because most policies have a change of definition at 24 months, which means usually you go from an own occupation to an any occupation. Any occupation meaning anything you can do based upon experience, education, and training, and a much more difficult standard of disability to satisfy. The reason they like to deny the claim before the change in definition is so that when you do file the appeal, like you said, or if you file a lawsuit, they try to say to the court, well, you only can consider the own occupation phase, and even if you do win, well, guess what? Now we're going to go back and do the whole thing over again for 24 months. But it sounds like when you did your appeal, you were aware of, hey, it's a change of definition, and hey, Hartford, I don't want you to just do the own occupation. You better do the any occupation now at the same time, since we've now rolled into that 24-month period.
And even in doing that, in this instance, in gearing any of the attending physician statements, questionnaires, it was not only just at what his occupation was, but also this idea of something that would have been in the same level based on his training, education, experience on it. But in doing this case, stumbled upon a growing body of research with respect to arthritis, psoriatic arthritis, rheumatoid arthritis, the standard seropositive arthritis, which, if you will, showing cognitive problems, almost akin to fibrofog. Everyone's familiar with the idea of fibrofog. If you have fibromyalgia, sometimes you have a hard time concentrating. That goes just above and beyond the general pain and fatigue. So armed with that information, we got him in with a doctor to be able to do neuropsychological testing. And that testing did document restrictions and limitations of his executive functioning and other things that would prevent him from going back into that really high-level executive position. We submitted the appeal, and before the end of the first 45-day period, Hartford notified us that they had approved the claim. This particular client even had a private policy with Unum, which strangely also had to change in definition. So we made sure to get all that additional information to Unum, and they've approved it. So at this point, we're managing the claims, and there's only a short time left on it. And another, layer into this, The client was 64 years old. There's only a year and change left of benefits on it, and they were still fighting him on it. So at this point, we're hoping that they've quieted down, they'll acquiesce to it, and there won't be any more issues. But it kind of goes to show that regardless of approval of Social Security, approval from other insurance companies, your age, how much the value of the policy is, and how much this may cost the insurance companies, they'll find any way to just, find this is how we cross our T's and dot our I's to deny a claim.
So that's crazy. They wanted to first beat him up at the change of definition and then try to beat him up again to get out of the policy, even though he's 64. And then this is why I tell potentials all the time that call us, it doesn't matter if you're 45 or 64, that we've seen them deny benefits at any stage. It's just not, they really don't care. If they, like you said, if they have any opportunity, they're going to try to deny the claim. And this isn't just Hartford. This is just about every disability insurance company that behaves this way. So it was great that you got that outcome. In this particular case, I'm sure the client was thrilled to get his benefits back. If you have a claim with Hartford or any other long-term disability insurance company, feel free to call any of our disability attorneys. We always offer a free consultation, and we're available to help you anywhere in the country.